It's time for another case law update. Today's case is Miko LLC versus Targa Gas Marketing LLC out of the Fifth Circuit Court of Appeals. This case involves a dispute arising from Winter Storm Uri and addresses how far a seller can go in relying on force majeure clauses to excuse non-performance under a NASB contract. First off, what's a NASB? In the simplest of explanations, a NASB is the standardized contract used to sell natural gas. Miko and Targa were parties to multiple natural gas transactions governed by a NASB. Under those agreements, Targa was obligated to deliver specific volumes of gas to Miko at different price structures, some fixed price and others indexed to market prices. When Winter Storm Uri swept across Texas in February of 2021, the demand for gas increased, and combined with a tight supply of natural gas, prices spiked dramatically. During that time, Targa delivered only a portion of the gas it had committed to deliver. Targa claimed that the storm constituted a force majeure event that excused its non-performance. Miko disagreed and sued for breach of contract, arguing that Targa failed to meet its delivery obligations and improperly allocated partial gas deliveries between a fixed-price contract and a variable spot market contract. The district court initially sided with Targa on the issue of force majeure, granting partial summary judgment and holding that Winter Storm Uri excused Targa's failure to perform. The court reasoned that the storm qualified as a force majeure event and that Targa was not required to purchase replacement gas at extreme prices to fulfill its obligations. However, the issue of improperly allocating partial gas deliveries between contracts was tried in front of a jury, which found in favor of Miko. Both parties appealed. Miko challenged the force majeure ruling, while Targa challenged the jury's verdict on allocation. On appeal, the Fifth Circuit took a more detailed look at the force majeure defense and concluded that there were genuine disputes of material fact about whether Targa's failure to perform was truly caused by Winter Storm Uri, including whether Targa's usual sources of gas, including third-party purchases, were actually unavailable. While the court acknowledged that Winter Storm Uri was extraordinary and disruptive, it emphasized that the existence of a force majeure event alone is not enough. To be excused from performance, Targa still had to show that the storm actually caused its inability to perform and that it exercised reasonable efforts to avoid or mitigate the failure, such as attempting to obtain gas from alternate sources, even if doing so would have been extremely costly. The court found that the record did not conclusively establish that Targa's gas supply options were completely unavailable, or that Targa had done everything the contract required to attempt to perform. As a result, the court reversed the summary judgment ruling on force majeure and sent that issue back for further proceedings. By contrast, the Fifth Circuit upheld the jury's verdict on allocation. The court found that the jury's determination that available gas should be delivered first to the fixed price contract instead of the variable spot market contract was supported by evidence and consistent with applicable trade usage and the parties' expectations. Additionally, the jury was entitled to determine that Targa should not have prioritized certain deliveries, especially those tied to more favorable pricing, at Miko's expense. In the end, the Fifth Circuit reversed in part, affirmed in part, and remanded the case. Their decision and findings are an important reminder for energy market participants that force majeure clauses are not automatic escape hatches. Even in extreme events like Winter Storm Uri, sellers must be prepared to show a clear causal link between the event and the non-performance, and must demonstrate meaningful efforts to mitigate or overcome supply disruptions. Like I always say, on the matter of force majeure, stick to the contract. That's it for today. I'd like to thank Tannen Sim, an associate in our Houston office, for his help on this update.